number 15, the people of the state of New York versus Cadman Williams. Counsel?
Good afternoon, Your Honors. My name is Mark Zeno, and I represent Cadman Williams. I'd like to reserve 2 minutes for rebuttal.
Yes, of course.
Thank you. May it please the Court. The question on this appeal is whether the trial court below, confronted with conflicting hearing decisions on two new scientific DNA techniques.
So I want to start with what is the actual standard of review. And I don't mean, was it an abuse of discretion, but in terms of this is sort of tension between Leahy and the Mold case, Cornell, in terms of, do we look at it at the time that the judge is issuing the decision? Do you look at subsequent developments? Do you,
Well, I think
what is the rule?
I think in Wesley,
in terms of that analysis.
I think in Wesley, which was the DNA case, the majority opinion was very clear that you look at it at the time the decision was made, and you don't look to subsequent developments in the law. And in fact, it would be really hard in a case like this to look to subsequent developments in the law, because the issue is whether there was the appropriate factual record upon which to make a Frye determination, to determine general acceptance.
Is the record different as between the issue of low copy DNA versus the use of FST?
Well, they're two different techniques, and they both had reasons in favor of admitting them and reasons against admitting them. So in that sense, the record is different. The defense made different challenges to each of them, and there were two different court decisions.
There is a common theme, though, isn't there? How much is enough before you decide to have a Frye hearing? You see, while the science is very complicated, the legal issue seems to be relatively straightforward. And so for us, we don't need to be experts in DNA. What we need to be is experts in the law and whether or not the standard was met here to require another hearing. And so there are some similarities, don't you think, between the two techniques and the legal standards required?
I couldn't have said it better. Absolutely, the court should not be trying to decide whether the science was reliable. The court should be deciding whether, when this court made a determination that no Frye hearing was necessary, that supported a general acceptance of reliability finding.
So what was the state of the law review articles, scientific studies? What was the state at the time in Williams the decision was made as to these two different issues?
And while you're addressing that, if you can also address what the requirement of showing that it's novel and how that fits into what
Okay, I will try to get to both of those questions. So to begin, these were novel tests. There's no question that they were novel, particularly with regard to FST. During the proceedings below, while my client was waiting to come to trial, the first report said only that he could not be excluded as a contributor. A couple of months later, they ran new tests with a new version of the FST or a new application of the FST, and they made a much more conclusive findings, saying that it was 4.3 million times more probable, and still months later they made an even more conclusive finding as to probability. So particularly with regard to FST, this was developing as the case proceeded. Nothing can show novelty more than
Well, there were four tests, weren't there?
There were four
starting
tests.
in 2011, and of the four tests, I believe the first test didn't show a match at all. Is that correct?
Could only say it only showed that my client could not be excluded.
And then by the third test, it showed a match and set up a likelihood ratio. And by the fourth test, that likelihood ratio had increased enormously over the third test. So there were, I don't know if that's unusual, to be honest, but there certainly was an unusual progression here in the analysis.
Yes, and I think it going to novelty, it shows a strong showing of novelty. The tests were still being
But
refined.
isn't really the novelty, see, Judge Stein's question goes to the heart of part of it here, I think, because isn't the novelty question, as far as FST, relatively straightforward, because it was developed by OCME, and it was a proprietary, they had a proprietary interest in it. They were the only ones using it, so it's about as novel as you can get. I think the more difficult, or I should say, the closer issue is LCN, and I think you should address that.
I'd like to do that. LCN, just as with FST, was only being used, this particular method of LCN was only being used by OCMA nationally in prosecutions. I believe there was one or two other places that used it for investigative purposes, but not as proof of guilt. Also,
Part of the question whether it was really the same as high
copy.
DNA, and therefore there's nothing new about it.
That's absolutely the question, and it is not the same as high copy.
Why is that?
and
Why
in-
isn't it the same?
In fact, the kit that's used for running, that was used to run the low copy number DNA testing here, was designed for only 28 amplifications.
And the difference being that with low copy DNA, it's 31 amplifications.
It's 31, as
And
far
what
as
does
I
that, what does that create in terms of differences between 28 to 31? Seems like a small difference.
Well,
Why is that
according
unique?
to the experts, it's not a small difference.
Well,
I
why?
mean, why is it not? Because it creates, it's a multiplier of error.
Doesn't it create 8 times more material from 28 to 31? Is that correct? Is that your
8 times
understanding
more
of it?
material. I'm not sure whether it's an
That's my
exponential
understanding
or an
of it. And
arithmetic progression.
so the error question then is whether or not it creates more errors in its replication and therefore isn't as trustworthy because of the large increase in amplified material.
That's correct.
Yeah. Now, what expert argued that in court?
We didn't have an opportunity
Right.
to present that
You
expert. to argue with
brought
the
some,
court.
you were going to bring in, how do you say his name?
Udall?
Yeah,
Right.
Budoli?
Budoli.
Budoli. Judge
Udoli.
knows,
I mean,
okay.
he's considered the father of DNA examination, and he found this test to be unreliable. And I believe he testified ultimately in the Collins hearing and said the same thing. And
Did he find it unreliable?
he found that it was not, yes, he found it to be unreliable, that it was not generally accepted as reliable. And that is the hearing, and that is the testimony that my client was deprived of.
So let's say you're right, that you should have had a hearing for the purpose of this question. Why isn't it harmless error?
Why isn't it harmless error? Because the jury, my client was confronted with the fact that a jury was going to hear that it was 125 times more probable that he and an unknown person held on to this gun than 2 unknown people. With that evidence against him, he had no choice but to take the stand and testify that he was justified in doing so. Without that evidence,
But it's, there, in this particular case, there was eyewitness testimony, there was his own admission, I mean, there was the video surveillance. So how does he get around all that?
okay, so let me take those one at a time. There was
Well, you have
videos.
to take them together.
Well,
but
I
you
wanna-
can, you can address them one at a time, sure.
There was identification testimony. I think in People versus Levan, under similar circumstances, they found that an identification testimony was not sufficient. So let's start there. There was surveillance testimony. I looked at the video last night again, and it is essentially figures moving in a way that the witnesses described, but there is no basis for making an identification on the basis of that. There was a single Rikers call where my client definitely did not confess to this incident, but said something vague about not doing a shooting or not doing another shooting or
I
words
thought,
to
though,
that
the
effect.
Irazawi testimony was, is that how you say it? Irazi? I'm not sure about the
Girlfriend.
name pronunciation. I thought that was pretty compelling.
It was, on its face, it was strong evidence of my client's guilt, but had there not been, it wasn't 125 million times more probable from a forensic scientist. That was the testimony he was confronting. And he really had no choice but to take the stand and present a justification defense when confronted with that testimony.
Thank you, counsel.
Thank you.
Counsel?
May it please the court, Robert McIver on behalf of the Bronx County District Attorney's Office.
Can I start with a slightly different question about novelty?
Sure.
Because I'm a little confused about that. I think, to me, the novelty is the end of the inquiry, which is it generally accepted as reliable? And if it is, then it's not novel, and if it isn't, then it is novel. So I don't understand this putting the requirement of having to show that it's novel before you get to the question of whether you're entitled to a Frye hearing. Am I missing something here?
So I think that the broader issue is that Frye's only implicated when we have something that is novel. And the issue, therefore, is that it makes sense to address it as a threshold determination under those circumstances. Now, I agree that general acceptance is intertwined in a lot of ways with novelty. The longer that something is around, the more likely that it's going to be generally accepted and that the scientific community will have an opportunity to evaluate it.
But I thought the question for Frye was, is there general acceptance among the relevant scientific community? And we talk about counting scientists.
So in Chief Judge Kaye's concurrence, she specifically says, the court...
Talking about Wesley?
That's correct, I'm sorry.
That's all right.
The court agrees unanimously that where the scientific evidence sought to be presented is novel, the test is that articulated in Frye. That implies that this would be a threshold determination, and interpreting it that way will place this court in line with California, Illinois, Pennsylvania, and Washington as well. It's not novel where it is a mere refining or sensitizing of an existing technology, and that's the issue. And I think that the touchstone of that inquiry is ultimately whether there can be a meaningful battle of the experts under those circumstances.
Well, let's take an example, because it's an interesting point, actually. Fingerprints. Fingerprints were once viewed as the DNA of evidence. They were the gold standard. That's not the case anymore, though, is it?
So I think there's a distinction to be made there in
But
terms of...
just as to my point, it's really not the case anymore. Fingerprints are not really viewed in the same way anymore. The statistical probabilities have seemed to have been reduced by the FBI numbers I've seen significantly as far as the use of fingerprints in identification.
So I think that there's 2 points here. The first is that it goes back to the original question today, is that it should be viewed at the time of the decision. That all of the Frye inquiries, whether we're addressing the threshold determination.
Yeah, but that's not my question for you. I understand that point, and that's a valid point that you're making. But the point I'm trying to make is that science changes, and that analysis must then change, and that in this particular area, there seems to be a profound difference between the experts that we've seen between HCN DNA analysis, which is, I think, is unquestioned as we're going to get right now, and LCN DNA analysis. Fingerprints do the same thing. Now, this court has had a number of types of forensic scientific methods that have been accepted and approved, bite mark analysis, and then we've given the stamp of approval to those techniques. And then later on, it's pretty much a consensus now that that was wrong. They don't provide those.
I'm reminded, I think that dovetails with the concerns articulated in the amicus brief from the Innocence Project. And our point is that novelty doesn't end all of those inquiries, whether it's novelty or general acceptance. And that's not only our point, that's how it's being practiced.
Mm-hmm.
Now, to take it a step further, you've identified fingerprints, and I would add to that tool mark identification. That's not novel.
sorry,
Tool mark identification. This was also, it was brought up in the PCAST report in a number of ways. So with respect to that, those aren't novel necessarily, but that doesn't end the inquiry
Well,
where...
then how can it be a threshold question?
It's a threshold question in the sense that it helps to avoid, I'm sorry, It's a threshold determination as to whether it is something that is simply sensitizing. So it's not a threshold determination that I think ends the inquiry, and it also doesn't create a situation in which that it leads to absurd results. And
So
that's
aren't we really looking at a number of things? We're looking at literature, we're looking at other court decisions, significantly, I think, maybe appellate court decisions, right? We're looking at what kind of, we're not just looking at any case decisions, because a lot of times, I think, one case just relies on another case, on another case, on another case, and nobody's really done any real inquiry. So I think the question that really we're all looking at here is how much is enough
in terms of the
to
underlying.
get you to the Fry hearing, yes.
To get to the Fry hearing, so my broader issue, I would say, is that the Fry hearings themselves don't offer all that much over the underlying submissions. And in fact, in a lot of situations, the Fry hearings create a misrepresentation of the state of
But
the
don't they create a record so that for courts to rely on, to review for reliability? And that's what we're looking for here.
I don't
And
know-
that's sort of the basic scientific premise, that this can be repeated accurately and get the same results with the same materials. Go ahead.
I think that the combination of factors articulated in Legrand between the peer review, the validation studies, the scientific literature, I think is the more important category. If you have kind of, and I think that happened in Collins in a lot of ways. I think that represents the potential flaws in overemphasizing hearing testimony. If you have the state, in our view, the state of the literature as it related to the FST and.
But that's not the basis for the court's decision
I think
below, is it?
In this case?
Yes.
I think it was one of the reasons that it didn't grant the hearing, is that there was nothing more that was going to come out of the hearing that wasn't going to be reflected already in the peer-reviewed literature.
Well, let's say we disagree with you. Let's get to the point of once you have conflicting hearing outcomes from other courts, what is a court to do with that? Once a judge knows that,
So-
why shouldn't the judge grant a hearing at that point?
Because all Legrand does is ask the courts to take judicial notice. It could take judicial notice whether something is a hearing or if it's simply a filing in another court.
You know,
So-
it's one of the things that strikes me is your theory places an enormous emphasis on the one Fry hearing that's held initially, and everything else flows from that. In this case, it seems we have two analysis that everything flows from: the Megnith hearing, where a hearing was held on the LCN, and then DNA analysis, and then the Garcia case where FST was not given a hearing.
Correct. And then there's also Rodriguez.
Right. Okay, but let's just say that. My point is, since then, there have been 140 cases that have cited, and they said, well, they held it here, so that must be good enough. But the point is that they relied on the same analysis. So if you just keep, it's like those DNA errors that they say, hey, if you keep replicating them, that doesn't make them true. It doesn't solve the underlying problem. It's, from a court point of view, we're kind of confronted with this Copernican problem. The Copernican problem is, what if the world isn't flat? What if the facts are wrong? And how do we test that? And since Copernicus, we have this method, this scientific method, where we decide what's right or wrong, and at least, and what we decided based on is, can it be repeated? Is it verifiable? Is it reliable? And that's what's sought to be tested here, and that's why I'm challenging your approach.
So I think that there's three answers to that. The first is that it goes back to my broader point with respect to the Fry hearings themselves. If you have a mountain on one side of peer-reviewed and validation studies, and on the other side you have a few scientific dissenters, that would alone, without a hearing, reflect generalized acceptance. And Fry contemplates a lack of unanimity on a lot of scientific issues. So you
Well,
don't.
does it matter where this, this review, this analysis comes from? For example, if it comes from the very entity that's using it, does that make a difference?
So the issue, I assume that this is in reference to OCME's internal validation. I think that the broader is.
Also, tack on to the answer, excuse me for interrupting you. Where does the Commission on Forensic Science and the DNA Subcommittee fit into this equation?
So they're independent. They're created by the legislature in particular to make sure that the that science in New York, in particular DNA science in respect to the DNA subcommittee, is done so in accordance with the highest standards under, the highest scientific standards practicable.
But how do we know if they represent a consensus in the relevant scientific community? These are certain people that are handpicked, right, by government actors.
They're handpicked for the purpose of representing the relevant scientific communities. And I think that that's an incredibly important distinction here, that it's not circular logic.
But don't you have now one member at least who has taken a different position?
And I think that that would be something that should be within the discretion of the lower court to look at that and say, maybe that undercourts that.
Going back to my question,
But
light is out, but this is, I'd like to understand from you your rule as to what is a judge to do when they have conflicting Frye determinations, and it appears that there's one member of at least one of those entities that you've described is now placing in question the use of the particular methodology. Why isn't that enough to trigger a Frye hearing? We're not saying the outcome has to be one or the other, just the Frye hearing.
It's to recognize the fact that the Frye hearings under that circumstance don't necessarily add much to the overall peer review, that they're not going to disturb validation studies, they're not going to...
But again, was that the basis for the determination below?
I think that the court declined to follow Collins in part because Collins wasn't actually applying Frye. It was a modified Daubert decision in which it simply looked at the conclusions and said it was placing emphasis on what it believed the correct state of the science was. It wasn't counting the scientific votes. And that goes back to my broader point.
Does it matter how long something's been around? In other words, if something's been around a really long time, then you would expect there would be more studies that may or may not contradict the original validation study or studies. But if something is, hasn't been used for very long, there really hasn't been time for all that to develop. Does that make a difference?
Not in the case of a sensitizing of an existing technology. When you're putting forward LCN DNA, which is basically the exact same 4 steps of PCR, you have the ability to make meaningful estimations very quickly with respect to that. And this was not something that developed overnight.
There was some testimony that was not true. So that's my point is, so you have the HCN, right? Mm-hmm. And then along comes the LCN, and you say one thing, but there's somebody over here that's saying, not so fast. But the studies haven't been done yet. That's my question.
The biggest distinction between LCN and HCN related to allelic dropout. And I think the Washington courts in Bander and Russell handled this well by saying allelic dropout is something that necessarily goes to the weight of the evidence, not admissibility under Frye. And I'd also note that in all forms of probabilistic genotyping and in all forms of DNA, there's going to be some uncertainty present in the estimation of various parameters, not just drop in and drop out.
In your view, what would be the circumstance in which it would be an abuse of discretion for a court to deny a Frye hearing?
If there's a substantial showing controverting the underlying science in a way that goes to the general acceptance that cannot be resolved by a battle of the experts. And that's not present here because we can look at the underlying submissions here and recognize that this is perfect for a battle of the experts, a battle of likelihood ratios, a battle of assumptions as to allelic dropout rates. That's the kind of thing that goes before the jury. That wasn't present here, and more importantly, the scientific dissent, which is contemplated under Frye, did not rise to the level of granting a hearing.
Can I just, sorry.
Please.
Yeah. If this case came to OCME today, right now, in 2020, would these same techniques be used to analyze this DNA?
This is with reference to, I'm sorry.
Both LCN and FST. Is it correct to say that neither of these techniques would be used by OCME now?
OCME upgraded its technology to not because...
No, I understand I understand the rationalization, but my point is they would not use either one of these techniques today, would they?
Only to ensure compliance with CODIS, not because they were worried
well,
about
there was a lot of controversy about FST. In fairness, it's sort of outside the record and really isn't directly relevant to your case, in fairness to you. that necessarily wasn't exactly the same with LCN, though to a lesser degree it was. But it is fair to say that OCME wouldn't use these techniques today.
They would use the new techniques that they have in order to.
Yeah, but that wasn't my question.
It was a
Well,
cost.
and-
No,
Well,
they,
that's my question. Why did they
Can I
change?
just get him to answer mine first?
no, they
before?
wouldn't. They have a
All
new
right.
technique.
That's
to
all I
go.
wanted to know.
To answer the question, what happened was the FBI and international protocols in order to decided that they were no longer going to test at 13 loci, and they broadened that to 20. We were using a test that identified 16. So in order to be compatible with these national and international databases, we had to change the underlying software.
But
Now,
isn't that some indication that maybe those national and international organizations thought that what was being done was not adequate?
no, because it was simply
reliable?
testing at more loci in order to make sure that it was a cost-benefit analysis at the end of the day with respect to OCME, that they believed that they could have re-implemented the FST, but ultimately looked at this and said, we have a determination here that we have to upgrade the software. And the software would require then revalidation as to both LCN and the FST, or they could use commercially available practices that weren't going to result in additional litigation. So it was not OCME looking at this and saying, cat's out of the bag, we've been wrong this whole time. It was a
I'm not
cost-benefit
suggesting that. What
analysis.
I'm suggesting is that those other organizations made a determination that they were not satisfied with the reliability of what was being used by OCME.
I cannot improve upon the OCME's handling of this. I would direct the court's attention to the respondent's supplemental compendium of materials with respect to OCME's letter, and then the DNA subcommittee's analysis, which ultimately determined that these were still valid under the circumstances.
Chief,
notwithstanding
Thank you,
the-
Counsel.
No, you didn't get a chance to address this, and I didn't know if there was anything besides what you've said in your brief that you want to address our attention to on the issue of harmless error.
The defendant, the people's own case indicated that the victim in this crime threw a baseball bat at the defendant. Ultimately, it was uncontested as to the issue of identity, and the appellate division down below recognized that DNA added nothing to the people's case, in part because of the testimony of the girlfriend, in part because the defendant took the stand and admitted shooting this individual. He said it was in self-defense. The people's own case created a colorable justification defense. The idea that he was going to change radically because we couldn't put in something like the FST, and that we couldn't put in any sort of DNA evidence, I think is speculative and beyond the point. Ultimately, the defendant in this case did not contest identity. DNA did not offer anything that we couldn't have achieved through alternative means.
Thank you, counsel.
Thank you, Your Honor.
Counsel?
To begin with, the point that opposing counsel made about this is an appropriate weight of the evidence review for a jury. Fry makes clear that there is a threshold beyond which scientific tests must pass before they are appropriately reviewed by a jury. I've spent the last 2 years studying FST and LCN, and if an expert was cross-examined in front of me, I would understand the concepts they were talking about, but I would be unable to opine about the reliability or how much weight should be given to that testimony or to that evidence. Only an expert can say whether it's reliable, and that's the genius of Fry, is to defer to the experts. And here, there was no agreement, no general acceptance by the experts. So I think that the idea that lay jurors can assess whether a test was reliable, whether it was multiplied, whether DNA was amplified 28 times or 31 times, and what the stochastic effects are, and what the meaning of drop-in and drop-out and stutter, that's a non-issue. No lay juror could ever understand that.
Do you want to quickly address the Del Debbio and justification issue?
Sure. On the Del Debbio point, counsel was ineffective because this was there were 2 shots fired, and he allowed, without objection, an instruction to go to the jury that if either of the 2 shots caused the victim's death, Mr. Saki's death, and either of them was not justified, then my client was guilty, and there was no justification. What was required under the circumstances was an instruction that it was the excessive portion of the force that caused death, and that wasn't given here. And that's a dispositive issue in the case. There was strong evidence that while the first shot might have been justified, the second shot wasn't justified, and an issue, an instruction on which the entire case can turn, if counsel doesn't insist on something that's authorized by the law, that's ineffective assistance
Thank you,
of
Mr.
counsel.
Zeno.
Thank you.